My name is Dr. Martha Gayoye, a lecturer in public law at the University of Kiel. We are going to discuss how judicial leadership in Africa is helping to safeguard rights and democracy. So onwards to Kenya's judicial leadership, they have been particularly active in supporting socio-economic rights, gender equality, and against amendments to the constitution that suit politicians' interests. The Kenyan courts are made up of the magistracy and higher superior courts made up of the High Court, Court of Appeal, and Supreme Court. As far as human rights are concerned, the High Court is the original court that entertains such matters. The Court of Appeal and Supreme Court entertain such matters only on appeal, which partly might explain why the High Court has exercised the foremost judicial leadership in human rights cases. They have made personal sacrifices and faced retaliation from politicians, from transfers away from the center of government power in Nairobi to regional courts and to media insults and slights. Judicial leadership can be defined in three ways: administrative, community, and adjudicatory leadership. Administrative leadership is commonly associated with governance of our judicial system, a role typically performed by chief justices. Community leadership is about connecting the courts with members of the public through media engagements, public events, and public lectures. Adjudicatory leadership is the influence of a given judge on the decisions of the court in a specific area or more generally, and may involve influence over time as well as persuasion in individual cases. It's the development of a line of thought at odds with the court's general position, which is nonetheless important. So for socio-economic rights, focus group participants described Justice Mumbi Ngugi, Justice Isaac Lenaola, and Justice Vincent Odunga as the foremost stalwarts in enforcing the right to housing in the High Court. They were supported by Justice Agrey Mushelule and Justice Daniel Musinga. These judges have insisted that socio-economic rights must be respected and that the government cannot simply say that they haven't got the money. In cases on the right to housing, such as Mitubel in 2011, 30,654 households were evicted from Mitumba village near Wilson Airport in Nairobi. In Satros Ayuma in 2010, thousands of tenants were evicted from Muthurwa Estate in Nairobi, while in William Musembi, hundreds of tenants were evicted from Upendo City Village in South C Ward in Nairobi from the privately owned Moi Educational Complex Center. In all eviction cases, children's education is brought to an abrupt halt in the middle of a school year, and families are suddenly cut off from livelihood. The judges held the government to account and insisted that they demonstrate their plans to provide alternative housing for those evicted out of informal settlements on public land. These plans needed to be clear with a time frame to which the government must report back to the court, a remedy known as structural injunctions. In doing so, these judges borrowed the structural, or also called mandatory injunctions remedies, from the constitutional courts of South Africa and India. In previous decisions, the government simply stated that they didn't have the money and that socioeconomic rights are not compulsory. These new decisions had far-reaching implications on the question of resourcing for socioeconomic rights, particularly in cash-strapped developing countries. The other implication is the extent to which courts will go in borrowing remedies from other countries where these are not explicitly stated in Kenyan law. The Court of Appeal was not convinced by the High Court to accept that. The Supreme Court upheld the High Court's leadership in borrowing remedies from fellow developing Global South countries. This enriches a global South-to-South borrowing that reverses the traditional North-to-South borrowing of best practice. The final implication is the extent to which the courts can supervise the legislature and executive, which adds to ongoing debates on the separation of powers paradigm. Global South constitutional courts are leading the debates towards a more active supervisory role of the courts. Justice Mumbi Ngugi also spearheaded the Pumwani Maternity Hospital case in 2012 involving the highly subsidized public Pumwani Maternity Hospital in Nairobi. Mothers give birth in deplorable conditions in which they share single beds with other mothers and their babies or lie on the floor with their infants. Those who couldn't pay the modest fee were detained until they could pay, with little to no food. The judge did not spare the government in her scathing remarks about the disregard for mothers' unique life-giving role. The judge gave the government time to report back to the court on the plans made to improve the hospital and to stop the practice of unlawful detention of mothers. The battle for gender parity. Despite numerous attempts from human rights activists and public interest lawyers to engage with policymakers and courts, Kenya's parliament has yet to reach the required threshold for gender equality. Particular High Court judges, Justice Daniel Musinga, Justice Mumbi Ngugi, Justice John Mativo, Justice Joseph Louis Omondi Onguto, who has since passed away, and Justice Chacha Mwita have insisted that the government has a duty to put in place the policy and legislative framework to realize gender parity. The third area is in constitutional amendments. The famous BBI 5 were Justices Joel M. Ngugi, Vincent Odunga, Jairus Ngaa, Chacha Mwita, and Mumbua Matheka, who successfully prevented an amendment of the Constitution by popular initiative in 2020, the popular initiative being the Building Bridges Initiative, also known as BBI, a result of a political handshake between the ruling and opposition politicians to consolidate their power after the 2017 general elections. The 5 judges insisted in the BBI case that the Constitution can only be amended through the exercise of the power of the people, clearly laid out in the Constitution. This decision was upheld by the Court of Appeal and Supreme Court. The Kenyan example shows the importance of judicial leadership in alleviating human and social suffering and safeguarding rule of law. Judges, however, don't do this in a vacuum. There are various public interest lawyers and human rights activists working tirelessly to engage with policymakers and courts. This is an essential piece of the puzzle in judicial leadership. Judges must never be placed on a pedestal, but an independent and fearless judiciary is key for a fully functioning democracy.